So, it was already mentioned, I develop background, I develop foreground. I may transfer my background and my foreground, but it implies that I will have also to pass on my obligation to grant access right to the other participant of an IMI project. So it's really important to keep that in mind, but I'm pretty sure that if you're participating already to community project, you are fully aware of this principle. So, now, concerning the access right, we have seen the principle, the basis. So, we have developed something, but we have probably to grant some access right. As a principle, access rights are granted on written request. But in your project agreement, you may consider that for some type of background or for some type of foreground, or depending on the requesting party, there is no need to set up a written request because it implies some administrative activities and it may limit or not facilitate the granting of access rights. So consequently, you may agree that in your project agreement, but it's really important to be aware that if you set up this derogation, you know how it will work. So when you discuss and when you will provide that in your project agreement, please consider this point. Also, as a basic principle, all the access rights are granted on a non-exclusive basis. Why? That's really simple. We are several in one project. We have developed this pen. I have to grant access right to A, B, and C. So consequently, I cannot grant an access right to A on an exclusive basis because of my obligation towards B and C. That's the reason why, as a principle, access rights are granted on a non-exclusive basis. But concerning access rights granted for direct exploitation, it might be the case that exclusive licenses are granted. But keep always in mind your obligation concerning research use purposes. But this might be an option. So when we are talking about the non-exclusive basis, we are talking about the access right for completing the project and for research use purposes. As a principle as well, when I grant an access right to the other participant, there is no right to sublicense, except if we agree between ourselves to do it otherwise. So it's also important. And this possibility to sublicense may be very useful in case of software. So it implies that you may consider that for certain type of access right, you will provide the right to grant sublicense, and for other, you won't. That's really important also to discuss this. And it's not because I will terminate my participation in an IMI project that it will affect my obligation to grant access right to the other participant. But now let's have a look on the condition under which the access right may be granted between participants, towards the affiliates, but also towards third party, depending on the purposes. So, considering the background, and considering the foreground that will be for which access right will be granted for completing the project, the principle is that this access right will be granted on a royalty-free basis. Concerning the background and the foreground for which access rights are granted for research use purposes, so the concept of more than academic research with a possible for-profit conception, you will have to discuss the term. It may be either on royalty-free or on fair and reasonable condition. But it doesn't imply that these two options, and especially the royalty-free approach is mentioned, that this approach will be the systematic one, will be the starting point for negotiation. So it's really important to consider the project objective and also to consider the nature of the foreground and the nature of the background, and also to consider if this background and foreground will be provided to a participant or to an affiliate. So that's really important to have this in mind. Concerning the access right to third party, we had a lot of discussion why access rights have been foreseen for third party. So let's at the beginning of my presentation, you probably remember that one of the objectives of the IP policy and of IMI is to ensure a swift disclosure, dissemination, and exploitation of the knowledge that will be created within an IMI project. And it might happen that none of the participants are the best to ensure the appropriate disclosure, dissemination, and exploitation. That's the reason why it has been foreseen some possible access right to third party, because they could be in a better position than any other participant in the IMI project. And this access right will have to be discussed with a third party. It's really important. It will be the term will be discussed on a case-by-case basis, but you have to keep this possibility in mind. You may have to grant some access right to a third party, but to be negotiated on a case-by-case basis, and of course, under fair and reasonable conditions, because at the end, the objective is not to provide access right, but to ensure the disclosure and the exploitation of the knowledge that has been generated. And all the access rights that will be granted for direct exploitation purposes will have to be negotiated on a case-by-case basis. So, you will have some obligation to grant some access right, but of course, and as mentioned, you will have also an obligation to disseminate as soon as possible what you have developed within the project. So, and in the IP policy, it's mentioned that you have up to 1 year after the end of the project. And in your project agreement, you will have to describe the material you intend to disseminate, and you will have also to describe how you intend to disseminate these materials. So, just to recap what you will have to consider carefully. Your background, the identification of the background. Concerning the foreground, how you will notably manage possible joint ownership. Concerning sideground, no access right have been foreseen, but perhaps you may consider the need to foresee that in your project agreement. Concerning the access right, besides the financial terms, you may also define the duration during which the access right will be granted to the other participant. So all these points will have to be discussed and extensively discussed between the participant, and as soon as possible in collaboration between the scientist involved, but also the lawyer, because as soon as you involve the lawyer, as soon as you explain them the objective of the IMI and the objective of the project, the discussion will be easier to manage. And you will have also to discuss some dissemination thing, as an example, as I mentioned, to describe the material you intend to disseminate. And you may also consider the need to set up an IP committee, which will be a mix of scientists and of lawyers. That may be very useful for a proper implementation of a project and for a proper management of your intellectual property generated within an IMI project. So, last slide, to summarize, a table to explain different objectives, different interests, only one policy. So how this policy try to handle this multiple objective, multiple interests, ensure dissemination, reward innovation, ensure fair allocation of right. And at the end of this IP policy, up to you to use the flexibility provided by this IP policy. Thank you very much.